going to get right into it. This is going to be very practical. As a typical patent attorney, I'm an engineer, so we're not going to fool around. We're going to get right to the nitty-gritty. Okay, so one major change you may have heard of is we're going to go to a first-to-file system. Now, the way the U.S., and that's March 16th next year. Now, the way the U.S. currently is, and we're somewhat unique in the world, is we're a first-to-invent system. Now, this is where you need your handout because that's pretty small up there. In fact, the handout doesn't even have it. So, okay, so what's going on here? We got three inventors. This inventor came up with the idea first. This guy came up with the idea second, and this was the last one to come up with the idea. Whatever invention is, new molecule, new machine, and there's a concept called reduction of practice. You can reduce invention of practice by building it or filing a patent application. In my scenario, inventor one filed here. The second person, inventor two, came up with it second, filed second. Inventor three was the last to come up with the idea, but the first to actually file in the patent office. Who wins? As of today, inventor one, because he conceived it first, and as long as he diligently reduced it to practice, he's going to win. That's a first-to-invent system. As of March 16, 2013, who's going to win? Inventor 3, because he got to the patent office first. So it doesn't matter who invented first, it's who runs off to the patent office and gets a patent application on file first. So that's why it's not first to invent, but first to file. So what does that mean? File fast. If you got an invention, you got enough information to do a meaningful patent application, you get it on file. Don't wait. So that's point number one. And we're a relatively small group, so if anybody has any questions, just ask them now. Don't wait until we move on. Okay. Now,
what's the usual cost to do an investigation for a patent?
It depends on the technology. An option, it's not legally required, is to do a search to determine if it makes sense to file a patent application and allows us to write a better patent application. It can be as low as, including our time and the searcher's time, is $1,500. And if you get into the high-tech computers or biotechnology, it could be $2,000 to $3,000. And then that's to decide whether to file. And then you have your patent application costs on top of that, which would include drawings, government filing fee, and the attorney time.
So $1,500.
$1,500 would be the minimum to determine if you have something patentable.
That's only for the search.
Yeah, that's a search. That's not a patent application.
No, right. That's $1,500.
$1,500.
Oh, $1,500.
Oh, $1,500 good. I may be slow, but I'm not that slow. Okay.
Okay.
Yeah, $1,500. Well, that's almost a year's worth of work. Okay. Is there a grace period for the inventor's own disclosure? Right now, under U.S. law, you get a one-year test period. You can take your invention and offer it for sale or write articles about it. And as long as you file your application within a year of when you did that, when you offered it for sale, you're still okay. It's called a statutory bar if it takes you more than a year. In theory, the new law allows for the inventor that one-year grace period, but the language is so weird, we're not sure how it's going to stand up. It says you have a one-year grace period, but let's say you disclose A and you want to improve on it and file patent on A plus B, you may not have the advantage of that one grace period if you're trying to patent A plus B, only if you exactly patent A. So again, our recommendation is file fast. Don't rely on that one-year grace period. File before you do any public disclosure. So in my view, the safest thing to do is ignore the provision in the patent law that supposedly gives you a one-year grace period and get the application on file as quickly as possible. The other thing to bear in mind, most foreign countries don't have this one-year grace period. Most foreign countries are in first to file. So if you have an invention worthy of foreign patent protection, let's say it's a product that will only be made in China or Thailand, offshore, because of cost considerations, you want to get on file before it gets disclosed so you can keep the right to go get a patent in China. Any questions on that concept? But the takeaway is the same on both of them, file fast. Okay, the United States has a unique requirement. The rest of the world doesn't. When you file a patent application, you need to describe the invention, of course, but you also need to disclose the best mode of practicing the invention. And that's been in the U.S. patent law for hundreds of years. And that hasn't changed. What has changed is you can't invalidate a patent for failing to do that. Right now, under the law, well, not right now, it used to be the law that if somebody failed to disclose the best mode, you could challenge the patent and say, it's no good, you didn't comply with that requirement. You were trying to hide how to practice the invention. You were trying to keep trade secrets, and that's inconsistent. You have to disclose the best mode. Congress, this is so typical of Congress, says, okay, we're going to keep the best mode requirement, but what are the consequences of not disclosing it? None. You know, so it's like having a tax law. What's the consequence of not paying your taxes? None. Same thing with the best mode. It's still there in the statute, but if someone sues you for patent infringement, you cannot challenge the validity or the enforceability of the patent because of failure to disclose the best mode. Weird, but you know, that's our Congress. So the law still says you have to disclose the best mode of practicing the invention, but you know, in theory, the patent office can check that. In all the years, and I don't want to admit how long I've been practicing, I think I've seen one time in probably thousands now patent applications where the patent office questioned whether we disclosed the best mode, and that was only because it was a published scientific paper filed by the same inventors after the date of filing the patent application. But the patent office doesn't check. So what do you do as the inventor? Well, it's now possible, if you don't disclose the best mode, to have trade secret protection and patent protection on the same concept. Let's say you have a better coating for, we have a client, Def, that does coatings for airplanes. And I'm not saying they ever did this, but let's say you have a better coating, you disclose enough to get a patent, but you hold back the very best formulation. And the patent office doesn't call you on that. Well, now you have a trade secret on that formulation, and at the same time, you have a patent. So you can go after somebody on two different levels. So you can get both trade secret protection and patent protection that can coexist under the law. So takeaway number one is filing a patent application may not give up trade secret protection. Takeaway number two, I am ethically bound to disclose the best mode. So if you're going to hide it from the patent office, hide it also from your attorney. It's like the criminal lawyers never ask their client, are you guilty? Because if the client says, yes, I did it, then they can't put them on the stand, so they never ask that question. So, and the smart criminals know not to answer the question. I'm not accusing any of you of being criminals. I'm just drawing an analogy here. So that's two concepts we've covered. First of all, elimination of best mode. A problem we sometimes have is an uncooperative inventor, particularly one who's been fired or quit or is working for a competitor, and they say, we're not going to sign the papers. We're not going to file a patent application. It is now possible to file a patent application without their cooperation. The patent application can be filed by the assignee, that's a person to whom the inventor is assigned, or a person to whom there is an obligation to assign. So what's the takeaway there? Get patent assignment clauses, agreements from all employees and all consultants. And that's always been our recommendation, but it's become even more important now. So to the extent you have employees, and it should cover everybody, even those that aren't really technical, the employment agreement should include an appropriate drafted employment or assignment clause for patents, for inventions, and also when you use outside consultants, you want the same type of language. Okay, patent marking. What's patent marking? Patent marking means you put the patent number on the product. And you probably see that, if you're getting really bored at the breakfast table and you pull out something, oh, look at all the patent numbers on the back. Why do people do that? The law is if you're selling a product and it's patented, or if you have a licensee selling a product and it's patented, and if you don't put the patent number on the product, you can't collect any damages for infringement until you put the person on notice they're infringing. The law says, it's not fair if people copied your product and you didn't tell them you had a patent. You got to put them on notice. And the way you put them on notice is put the patent number on the product. Okay, that's pretty straightforward. And so we always recommend when we set a patent to a client, we have a cover letter that says, don't forget to put the patent number on your product. However, that's kind of inconvenient and expensive. And the way it's commonly done, you can put it on the product, or you can put it in some instances the packaging for the product. But every time you get a new patent, or particularly if it's a molded product, what do? Go back in and change the mold, or you change the printing, and then when a patent's expired, you got to go back and change that and delete that, and so you have patent pending, and then what about foreign patents and all that? The law has caught up with technology. A new option is to put a reference to a web page, and on that web page put your patents. And that's very easy to update. You don't have to change the product. So, and I think this is a secret a lot of companies don't know about yet. So our recommendation is, from now on, whenever there's patent, you just say see, for patent, see such and such web page, and then have a link to that, and then keep that web page up to date. Say, for these products, we have these patents. For this product, we have these patents. It's a lot less expensive way to do it, and more efficient. And you don't have to wait till you change your packaging. You can, as soon as the patent issues, you can put the number on.
So if it's patent pending, would you just put a picture of the product and the words patent pending next to it?
It could be a picture of the product, or be the catalog number and the description, and you say patent pending, and then when the patent issues, you put U.S. patent number such and such, or European patent number such and such.
Just the number, or would you have to actually post the patent?
Just the number.
Just the number.
Only need the number. It's putting people on notice, and if you know the number, it's easy to go online and get a copy of the patent. Okay, so is that concept clear? Either you're totally lost, or I'm really doing a good job tonight. Okay.
And it would be really handy when you have inventions that are covered, and articles that are covered by multiple patents, like 20 patents.
Yeah, well, I mean, I know ladies in the audience might know a product called the InStyler. It's a hairstyling tool. I can bring it out. It's been very successful, and we got patents in Korea and China and all over the world. I'm assuming people in Korea and China and the United States and whatnot. Yeah, but it's been very successful, and that's one way to keep up to date on the patent, just with a web page, instead of having to change the packaging for whatever country they're selling. And a potential issue is what we call false marking. If you put a patent number that doesn't cover a product on the product, or an expired patent, a competitor that's being harmed by that could sue you for false marking. And by using a web page, you're reducing the risk, because it's very easy to change it out when the patent expires. And you don't, you just do a reminder. You don't have to go back to the manufacturer or the packager and say, hey, change this, change that. So a lot of advantages to using the web page alternative. So my two takeaways are mark and use a website for marking. Okay, how to decide whether to file a patent application. It's really not an American Invents Act, but I think patents, again, Mr. Mack's going to be upset with me for saying this, are overused. That people don't do the analysis in advance before investing in the patent. So one of your handouts is this checklist from the book, and these are the questions that you get asked before you file a patent application. And I'm going to take you through these very quickly, if that's okay. The first one is it different? Is it new from what's already out there? That's what a search helps answer. If it isn't, why are why bother? You can't get a patent. So the first question, sit down, is, are we different? The next question is, are we better? If you're not better, nobody's going to copy it. You don't need a patent. A patent only gives you the right to keep others from copying your invention. If you're not better, why bother? So, what am I better? Can you do something that wasn't done before? Or can you do it cheaper? Or can you get a better result? In my hairstyling tool, certainly not cheaper, but according to the ladies, it does a much better job than anything else out there for straightening hair or curling hair. My wife has one, and she just, my big problem is always on the counter, and I'm always burning myself on it. How large is the potential market? If the market's only $100,000 a year, is somebody really going to come in after you and try to take that market away? Now, if it's $100 million a year, yeah, that's a yes. So, analyze. And it's not here, it's discussed in the text. The most important question is, can we do this at a profit? If you can't make a profit from it, who's going to copy you? Nobody. How long will the market exist? So, this pace of technology change is so great. If you have a technology that you think is going to be outdated in 3 years, don't bother. By the time you get a patent, it's going to be outdated. So you need you need an invention that's going to be in the marketplace, for at least 5 years, I'd say. How likely will there be competitors in the market? If you don't have competitors, if for whatever reason you have an enviable position having 100% of the market, then why patent it? Nobody's going to come after you anyway. How about contracts? Can you contractually prevent people from copying? We have a client that makes specialty chemicals, and people often approach them and say, "Can you design something that will do X, Y, Z?" And they say, "Sure, we'll do that for you, but you have to agree not to reverse engineer our composition and not go anywhere else for manufacturing. If you like what we do, you got to buy it from us." So, and that's a legitimate basis for contracting. So why get a patent if you can contractually tie up the person who wants to buy it? If you can't do it yourself, can you license it to third parties? Is there a potential licensee out there? If you can't do it yourself, if you don't have the capital or the ability to do it, and you don't think anybody's going to license it from you, why invest in a patent? Can you protect it as a trade secret? Trade secret protection is, at least initially, it's cheap. All you have to do is nothing. Just keep it secret. Now, secrets have a way of coming out, so that's a disadvantage of them. And some products can be reverse engineered, but if you have something that can't be reverse engineered, and you can adequately keep it secret, I think that should be an alternative, should be considered. Next question is about the best mode. And I have to put it in there, we're disclosing the best mode. Is that something you really want to do? But you have the option of trying to hide it now. How about other alternatives besides trade secrets? What about a copyright? Dan and I have just been suing somebody for infringing some toy cars. There's no patents on the toy cars, there's copyrights on them. Covering the appearance. Or trademarks, trade dress. The old figure 8 Coca-Cola bottle? Mm-hmm. No patent, but they have trade dress rights. Nobody can use a bottle for a soft drink that looks like that because people will be confused. And then a tricky test, but it's statutory, is the invention unobvious to a person of ordinary skill in the art. You can't get a patent for making just a minor change. I think one of the leading Supreme Court cases dealt with, you can tell how old this is, they replaced doorknobs with porcelain. And the Supreme Court said that's just one substitution of a material for another, that's not patentable. So you have to have something beyond the skill of the ordinary mechanic. So, is it unobvious? So that's, anything else on this checklist? I think. Yes. Do you own it? I can't tell you the number of times somebody's come in and said, I want to patent this. I said, okay, well, who's the inventor? Well, it's not me, it's this guy over here. I said, well, do you own it? What do you mean, do I own it? Well, has he agreed to, you can't patent it, you're not the inventor. Has he agreed to assign his rights to you? Oh, no, not really. Well, then why are we bothering the patent? Or I have somebody that works for a university comes in and says, hey, I've come up with a great invention. I said, well, was this in your lab? Yes. I said, well, what about your employment agreement with the university? Oh, employment agreement probably gives it to the university. So make sure you own it. And can you detect infringement? Let's say it's a manufacturing process. Can you tell if somebody's actually infringing from their product? If not, you might get a patent you can't enforce. So before filing a patent application, before involving Mr. Mack, go through the checklist.
Jeffrey, do you use a rule of thumb in advising clients as to like what magnitude of projected commercial activity would justify filing?
I tend to use like $1 million a year in sales. If you have that potential, even if it's questionable patentability, it's worth filing because the patent pending that you can put on the product will at least delay, if not scare away competitors for a couple of years. So, yeah, $1 million is certainly a safe number. Sometimes it can be less. I mean, you never know for sure what you're going to do. You know, I mean, the odds are better than Las Vegas where you're guaranteed to lose, but long term. But you know, most patents don't prove valuable in that the products aren't successful, or it's too easy to design around, or you can't get good patent protection. But those that are valuable are you know, the values incalculable.
How, in this day and age, outside the United States, how successful are you when you go after somebody, sue somebody for a patent infringement, copyright, or even a trade secret? What is the success ratio percentage?
Well, it varies from country to country. It's funny, those countries that tend to have the strongest economic system have the strongest patent system. So Germany, a lot of European countries, it's easier to enforce a patent than the United States because litigation is less expensive. Japan is pretty good, but the Japanese attitude is, please resolve the matter, you know, settle it. So they really push you hard towards settlement. But it's a good business tool. China, you know, ask me in a year. We've got 3 cases there in Newfoundland over the next couple months. It's certainly getting better. How good it is and can we avoid being hometown, I'm not sure.
Well, one indication I found is that in the last few years, China actually starts to have a contingency practice that tells you that the lawyers are actually winning money. Otherwise, they wouldn't be doing contingency.
Right.
Yeah. So I mean, there are contingency, and we're talking to people about taking our cases on contingency.
And does the fear of the litigation help at all? Even just the fear, you know, you go in there, the lawyers come in.
I think so. I think you know, if you got, once you start an aggressive enforcement program, the word gets out, and people get, you know, it's like anything else, like a burglar who's going to pick the house without an alarm. Mm-hmm. So it does have that deterrent effect. Example I like to use is Mattel has brought some cases that courts have labeled ridiculous on Barbie doll, like the Barbie doll song, and somebody did some weird sexual things with Barbie dolls and Ken and whatnot. It's a commentary. And Mattel went after them and lost. But it does make people think twice about doing anything with Barbie.
Mm-hmm. You said about, just real quick, about protection, being able to put patent pending or patent pending on there. Mm-hmm. But for the provisional patent, you're able to put patent pending on it for a year. So if you can get to market very quickly, is that a pretty good deterrent then?
It can be, and people don't know it's only a provisional. Mm-hmm. So that's
if
one.
you get to market that quickly,
yeah,
because you only have a year.
Yeah, provisional. I'll briefly talk about it. A provisional is a filing. It's called a patent application, but basically you can almost throw anything in it, you'll get a serial number, mm-hmm. And you will now have patent pending. It should at least describe the product you're putting patent pending on, and they can be relatively inexpensive. The filing fee is $100, $150 instead of $1,000 or $2,000, and it takes less attorney time to prepare. The risk there is people say, do it cheap. Well, if you do it cheap, you may not end up with a document that entitles you to a regular patent. The provisional is only pending for 1 year. Within a year, if you want to get the benefit of it, you have to file a real patent application. So actually, the total cost is more than if you did just a regular. Another advantage, it adds a year to the term in the U.S. instead of 20 years from the filing date, it's 21 years. So whether or not to do provisional is not an easy decision, but it is a cheap way. If you only want patent pending for 1 year, that's all you care about, sure, go provisional.
What about the term service mark? Is that still being used in your practice?
we're moving to something completely different, which is trademarks, service marks. Does anybody mind if I answer the question, because it's kind of not related to what the talk? Okay. Trademarks. Trademarks are in service marks. They're, you know them. Kodak, Coca-Cola, Bank of America. Trademark service marks. Trademarks are for goods. So a Kodak camera, Kodak film, when it existed, would be a trademark. Kodak developing services would be a service mark, because they're providing services. Sheldon, Mack, and Anderson is a service mark. We have no product. We're providing service. Bank of America, you know, they give you dollar bills, but do not theirs. So to answer your question, yeah, service marks are very good. I mean, you know, a lot of companies have them. National Notary Association has it. Example, San Antonio Winery. Yeah, one of our clients, they have a lot of brands for their wine, but they also have a restaurant. So it's a service mark for the restaurant and a trademark for the wines.
Thank you.
Okay, so we go to the handout, take away, file, only if it makes business sense. Okay, something new in the American Invents Act, that's part of it's been here for a long time, is how to challenge competitors' patent applications and patents. There's a procedure available for challenging a pending patent application. Up to now, the most you could do is send to the examiner a bunch of references and make the examiner look at them. You now have the right to submit to the patent office with regard to a pending application. And let me back up. You know it's pending because about 99% of patent applications in the U.S. are published 18 months after the filing date. So and it's available to the public. You can send references to the examiner with a discussion of them and say, you shouldn't issue a patent on this because. And that's an available option. The advantage of it, you may head off a patent and therefore a patent suit. The disadvantage of it is you really don't get to participate in the arguments back and forth. So you submit it and then you get to watch what happens. But to keep that option available, if you have some known competitors that are active in the patent office, track their patent applications in the patent office. Keep an eye on them, see how they're proceeding, and consider the option of submitting prior art. Nothing else may delay issuance of a patent. Now, if a patent is issued, one way to challenge a patent is get sued and fight it out in court. Expensive. Even a relatively minor lawsuit, let's say $500,000 to $1 million in damages at stake, could easily cost, it probably will cost $1 million to fight in court. That's the nature of the beast. The federal court's expensive, that's where you are, and patent litigation is expensive because it involves technical questions, complicated area of the law, expert witnesses, damage experts. It's the second most expensive, complicated type of litigation behind antitrust. So there are options available to challenge the patent in the patent office in an administrative proceeding. And the three of them are called ex parte reexamination, inter partes review, and post-grant review. I'm not going to discuss them. You don't need to know that. All you need to know is they're available. That's an option. And there are certain advantages to them. One, reexamination, if you request reexamination, over 90% of the time the patent office is going to grant reexamination. We've killed some patents using reexamination. And the advantages are it's lower standard of proof. When you're in front of the patent office, it's a 50-50 percentage. In other words, the examiner only needs to be at 50 or 51% to kill the patent even once it's issued. In court, you need clear and convincing evidence. So it's much harder to invalidate a patent in the patent office and in the courts than in the patent office. Second, it's less expensive. Not cheap. The patent office, I think, charges now about $20,000 for an application for ex parte reexamination. But when you consider that to 7 figures for a trial, it's a bargain. Even if you get sued and you file for this challenge in the patent office, there's a reasonable chance the court will do what we call stay the litigation. So the lawsuit, the expensive lawsuit, will just sit there while you continue to make product and make money while you fight it out in the patent office. And, let's see, what else I got? The disadvantage is what we call estoppel. In two of those proceedings, if you don't bring certain defenses to the attention of the patent office, you can't bring them in front of the court. You only get one shot at it. They don't let you fight it out in the patent office and lose and go to the court. So that's a disadvantage. But it's an option that, never black and white, but an option to be considered. So takeaway, consider patent office options if ever sued for patent infringement. I know I'm done, but I have some great quotes for you. You want to see some great quotes? Okay. This is from the Commissioner of Patents of the United States back in 1899. Everything that can be invented has been invented. Heavier than air flying machines are impossible, said Lord Kelvin, of the President of the Royal Society, and Harry Warner back in 1927. Who the hell wants to hear actors talk? So if you ever come up with an idea and you run into a bunch of naysayers, remember these great, brilliant people who absolutely don't. Any questions?
What about timeline?
In
From
terms of,
beginning to end?
to get a patent?
I come to you, I said this great idea,
I'm going to tell you a story.
please.
And then you appreciate it. My oldest daughter went to the same law school I did. And I had the privilege of getting up there because in giving her the diploma. But I remember the speech by whoever was it? I guess the president of the university, whoever gave the speech. He said, when you all came here 3 years ago and we asked you a question, because you weren't lawyers yet, you responded, I don't know, which was the right answer. Now that you're almost lawyers, when we ask you a question, you respond, it depends. Which is true. It depends on the technology. For example, the patent office is backed up as soon as there's a new technology, the patent office is always trying to play catch up because it didn't know it was coming and doesn't have the people to examine it. So the patent office is still backed up in biotechnology, still backed up in computer software. But if you got a better widget that's improvement over widgets that have been around forever, you can get pretty fast attention. So that's one reason why it depends. So another is design patent applications, which are directed to the appearance of a product, not how they work, get fairly quick turnarounds. And the third factor is there's ways to expedite applications. One way is you just pay, I think it was $5,600 and they'll put you in the front of the line. Simple as that. And I think you got a design patent in what, 2 months for somebody?
3 months.
3 months, sorry. I overstated it. So, but I tell client, the goal of the patent office is to get all utility patents resolved in 2 years. It does not. I'd say from the search all the way through getting a patent, if you get the patent, you're 2.5 to 3 years, unless you try to move it from the line, or you're in a backlog technology.
I think it's well worth paying the $4,800.
It depends. Sometimes you don't want a patent in a hurry. Let's say you have a new drug. Where's the economic value of a new drug that's successful? At the end of the term. So that's the type of situation where you file a provisional application, and the law is that the patent office doesn't move fast enough, and you are delayed in getting your patent because of the patent office delay, you get some extra term at the end. So the drug companies milk that for all that it's worth. They don't want a patent in a hurry because they don't have FDA approval. They wait and wait, and then try to extend it at the end. So sometimes you're not in a hurry. So that's why, for all those reasons, it depends.